Archer and HMRC.
If it please your Lordship, I appear on behalf of the appellant, Mrs. Archer. My learned friend, Mr. Yates, appears on behalf of the respondents, HMRC.
Yes.
My Lord, I have three essential submissions, and I believe I'm not going to take very much of the Court's time. I will make these points good. The three essential submissions are that Section 222, the right to make statutory representations, was not an adequate alternative remedy. The second proposition is that the judicial review tests the lawfulness of the process by which the accelerated payment notice was issued. And the third proposition is trite, that the judicial review must be issued promptly and in any event within 3 months of the time when the cause of action first arose.
Yes.
And your Lordship will see that I say that it first arose when the APN was issued. Now, if I'm right about those three propositions, then there's no real choice for Mrs. Archer as a prospective litigant. She had to protect her position by issuing the claim form when she did. Now, I accept that conceivably a litigant who issued their claim form late, that's to say outside the requirements of issuing promptly and within 3 months, might have asked the Court to exercise its discretion to permit a late claim form, but an appellant like Mrs. Archer shouldn't be placed in a position where her only prospect of litigation is to seek the Court's exercise.
Well, she could have put the revenue on the spot, couldn't she, by writing a letter saying, I plan to issue JR, but at the same time I intend to take up the Section 222 representations route. Please confirm that you won't take any point on timing if I don't issue it until after I've been through that route.
My Lord, I don't believe that it's possible for the parties simply to waive.
Well, it isn't possible for the parties to waive, Mr. McDonald, but if that had been done and the revenue had said, yes, we agree, no court in this country would have said that you were out of time for bringing a JR. It's obviously sensible.
Yes.
Obviously sensible. It's the sort of thing that happens all the time. Not only in JR, but in all sorts of cases where there are time limits, parties agree. The fact that ultimately it's for the court doesn't detract from the fact that the parties have agreed it. No judge is going to turn around and say, well, actually, terribly sorry, even though you relied on what the revenue said, you're out of time. Anyway, there we are.
Well, my Lord, that isn't what occurred in this case.
No,
and
right.
as I will show your Lordships, it isn't what has occurred in any of the other cases that there have been to date about accelerated payment notices.
Yes, but really it's a matter of common sense, isn't it, where you have a statutory scheme which can, in principle, only be challenged by judicial review, but which also has built into it a provision for the making of representations. I mean, surely Parliament must have intended you should go down that route first if it offered any reasonable prospect of resolving the dispute before adopting the last resort remedy of JR.
Well, my Lord, I don't easily accept that, and the reason is that the statutory representations route is really not about the lawfulness of the accelerated payment notice in a public law sense. So the judgment below indicated that the main basis of challenge to it would be that you're challenging the amount, and in challenging the amount, you're saying, well, there should have been no amount, therefore there should have been no accelerated payment notice. But really, the mechanism for challenging the amount didn't contemplate unlawfulness. I mean, it contemplated, if you're challenging the amount, you contemplate that there's a lawful accelerated payment notice, but the amount is wrong.
Yes, I see that. But of course, you can also challenge whether conditions A, B, and C are satisfied. And one of the things I'm not really clear about is whether it's your client's case that those conditions didn't apply to her.
Well, I will show you that in some detail. It is part of her case that the conditions didn't apply to her, but the essential basis of her case was that the revenue could not, on a bona fide basis, have decided that tax would be payable by both her and her husband.
You're going to need to make that good, at least to satisfy me at the moment. Because well, we need to understand how the scheme was intended to work. We need to see the DOTAS notice, which I haven't yet seen, the notification.
Yes, well, of course there wasn't one in my client's case.
Well, there was in relation to the scheme. I mean, the scheme which is referred to in the AP, in the advance payment notices.
Yes. My Lord, let me take you through the facts.
Yes.
My Lord, if you would take up the supplemental one.
Yes.
Yeah.
So we don't have all the documents relating to Mr. Archer in this bundle because I suppose it wasn't anticipated that they'd be relevant, but I'll do the best with what we have. So, and your Lordship's sort of seen some of the background in the judgment below. So, many years ago, Mr. Archer entered into a tax avoidance scheme which involved essentially creating a loss artificially by buying certificates of deposit at a high price and selling them to a third party at a low price. And in order not to actually lose money by doing that, he granted an option to his wife to buy the certificates from him for a low price, and she then sold that option to the third party for its market value, which was high. And then the third party exercised it and purchased the certificates from him for the low price, which she received approximately £6 million in the process, which presumably she made him whole in some way.
Well, I mean,
we don't know that.
in sort of economic substance, he made a gift of £6 million to his wife, and thereby hoped to generate an allowable loss for income tax purposes.
My Lord, that's so. So that was by specific operation of the provisions that related to certificates of deposit and like
That's section
instruments.
551.
It was. It was.
But it's not just that. You have to look at the section that provides for losses as well.
Well, my Lord, I'm not here to defend
I know, but
the
we
scheme.
need to understand
The scheme.
in order to understand the procedure.
So, what has now occurred is that subsequent to the judicial review proceedings, the Revenue issued a closure notice to Mr. Archer, and he immediately paid the tax that they assessed on him pursuant to the closure notice. And the Revenue and Mrs. Archer settled any issues in her case on the basis that nothing was payable by her. So there was a Section 54 agreement between Mrs. Archer and the Revenue.
And this was all after the judicial review proceedings?
This was, indeed, it was just after Lord Justice Patton granted permission to appeal the refusal of permission for Mr. Archer's judicial review. So your Lordship will see this, I think, in the application for costs originally made to the Master, which is in the supplementary bundle at tab 19. So in paragraph 22 of that, it says the ultimate outcome of the judicial review in Mr. Archer's case cannot be known because the case has now become academic as a result of HMRC's subsequent issue of a closure notice in July 2015.
Well, that doesn't explain why it's becoming academic. I mean, it only became academic because he decided to pay the tax on this.
Yes, he paid the closure notice, of course. He didn't appeal it.
On appeal. Right. Well, that's a rather material factor which isn't stated in paragraph 22. Perhaps. Yeah.
So he paid the tax.
He paid, yes.
Yeah.
He paid in July 2015.
So after the closure notice was issued, he then paid the tax in accordance with it.
He paid, yes, exactly, my lord. He paid within 30 days as it required. So he objected to the accelerated payment notice in 2014, requiring him to pay in advance. he objected to the fact that both he and his wife were asked to pay, so effectively they were asked to pay 12 million when the revenue had most recently said that they would accept £6 million. But then when the revenue did what followed the normal mechanism of issuing a closure notice to him, he paid immediately.
Supposing he'd appealed that closure notice and the matter had gone to the FTT, I mean, then the matter would have been fought out in the usual way before the specialist tribunal. And if he had won, he would not in a normal way have been able to recover his costs, would he?
He would not. No, he would not. So it would depend. The tribunal does have a procedure called a complex category of case where there can be a cost order.
And also where there's been unreasonable behaviour.
Yes, but the complex category, this might have been a complex
I
category
see,
case. It's pure speculation because
Yeah.
it wasn't an appeal. But normally a complex category case would be a case involving counsel.
Yes, I see.
But the
Yeah. In fact, to be fair, paragraph 14 of your submissions on the previous page does actually refer to the fact that Mr. Archer paid the tax after the closure notice was served, and that's why it said that the appeal was academic.
I'm very grateful.
Thank you. Yeah, that fills the gap.
So these matters are sort of long since common ground, and I didn't anticipate questions.
Well,
I'm so sorry.
I know, it's just I feel we need to understand, at least I feel we need to understand the background of the
Yes.
scheme before we can really test these propositions about
Yes.
whether it had to be a joint application for JR, whether in fact they were alternative claims or cumulative, and so on. And at the moment, my understanding is that the revenue, although for negotiation purposes they made it quite plain they would be content with one lot of tax, as a matter of law they were saying they were entitled to both.
Well, my lord, effectively they had, if you like, they had a statement of case saying that they're entitled to both because they didn't know which one was going to prove to be correct
It's not quite,
ultimately.
I'm not sure that's quite right. And that would be a case of true alternatives where both can't coexist. But I think in principle you could have a situation where Mr. Archer was not entitled to his allowable loss as a matter of income tax, and then as a matter of capital gains tax, Mrs. Archer had incurred a chargeable gain on the disposal and exercise of the option.
My lord,
Total £12 so that just teaches you not to indulge in tax avoidance.
well, teaches Mr. Archer. He teaches Mr. Archer.
Mr.
not to,
Archer,
yes.
yes.
I mean, I would submit that if one scenario in which his allowable loss creation scheme based on the certificates of deposit would have failed would be that they were not real transactions.
Yeah.
And if they were not real transactions, then I think that the gain wouldn't arise to Mrs. Archer.
I can see all sorts of arguments both ways, but I mean, what I'm, I think, probing at is the proposition that these were truly alternative liabilities to tax, one of which could not exist. I think only one of which could actually be right.
They were not pure logical alternatives. There would have been some possibility, as your lordship says, for there to be tax for both, but the revenue had accepted that certainly, if you like, they had communicated that a settlement offer based on payment of tax by one or the other would be acceptable to them.
Well, that's a matter of settlement negotiations as
Yes.
opposed to the strict legal position.
It is. But even so, my lord, the fundamental basis of the judicial review, of my client's judicial review, was, in my submission, entirely valid in that the revenue cannot have been sufficiently certain that tax was payable in both cases, and accordingly the revenue should not have issued accelerated payment notices to both. And the accelerated payment notice does not entitle the revenue to effectively issue them protectively where they think that there are two alternative positions.
Another puzzle is we don't really know what it was that persuaded the revenue to change their tune and withdraw the notice, other than the rather Delphic statement that was contrary to best practice.
We do not, my lord, but I think that I would invite the court to make an inference from the timing of that. So the fact that it occurred on the same day that a defence was served that related only to Mr. Archer's claim. So a claim was issued by joint claimants.
Yes.
The defence, the summary grounds of defence.
The defence only related to Mr. Archer,
Yes.
and they caved in on Mrs. Archer, and you say, well, the obvious inference is that they determined they didn't have a defence to her claim.
Yes, my Lord, I would say the obvious inference is that they determined that in the course of their preparation of the defence.
Yeah.
Because otherwise the defence would have addressed her case as well.
Yeah.
Now, we had criticised for issuing what we call a pre-action protocol letter on the same day that we issued the claim form, although three days before we served the claim form. The Revenue never responded to that letter, whether it was a pre-action protocol letter or not. They never responded to it. So in my submission, both sides can be criticised for aspects relating to the pre-action protocol. I mean, the difficulty is that in practice, when litigants are faced with a very short time limit that applies in judicial review claims and the requirement to act promptly, you can't simply wait until the end of the last day of the 3-month period. There's very little time in which to issue a pre-action protocol letter and await a response to it, even if you offer an abbreviated time for a response, if you've also got to issue your claim form in time. And as I've attempted to explain in my skeleton argument, rightly or wrongly, Mr. and Mrs. Archer took the view that their best approach was to issue a joint claim form, and therefore the time limit, in fact, expired 3 months after the issue of the accelerated payment notice to Mr. Archer, which had been in September 2014.
I know it's easier to be wise after the event, and of course these were very early days of the APN regime, but even so, as my Lord Justice Floyd has put to you, I mean, it would have been perfectly possible to write to the Revenue saying, we have these two forces in action, we want to sue both, please don't let us suffer for JR purposes, merely because we're not issuing a claim form now. Surely that would have elicited a sensible response, at least I hope so.
As I said, my best answer to that isn't what has happened in any of the other cases, and in my submission of the statutory representations procedure, which I'll make this good,
Yes.
but really isn't intended to address these sort of public law type of issues.
But have any of the other cases actually dealt with this issue of the relationship between JR and the representations machinery?
Not in as much detail as the present case.
Sorry, that's the present case?
Yes.
No.
So, if I can complete my brief narrative of the facts.
Yes, I'm sorry.
To make sure that
all over the place.
But I'd just like to make sure that the material that I do have with me, the court is aware of. So what we have here is
What we have where?
in the supplementary bundle in
Yeah.
tab 1.
Okay.
The letter to Mrs. Archer.
So this is what we call a precursor letter. So on the third page of the bundle, it asserts that Mrs. Archer has used a scheme with a reference number.
Yeah.
In fact, as the judge below explained, she didn't use it. She was a counterparty to her husband's transactions in it.
So wasn't that counted as using it? I mean, or at least arguably. And I simply don't know. If we haven't actually seen how the scheme was notified to the Revenue in the first place, it's very difficult to criticise the proposition that Mrs. Archer was also involved in.
Well, my lord, I fully accept that she was involved
Yes.
as a counterparty, as it's been put below.
She had to be a counterparty who Mr. Archer was going to be relaxed about giving £6 million to, presumably.
Yes.
And she also had to be his spouse for the purposes of one of the CGT arguments. Well, also I gather from the Revenue statement of defence.
I'm not sure that the Revenue are right about that. The essential basis on which she should pay no CGT is that they're exempt instruments.
Well, as I understand it from the Revenue's response, there was a two-pronged argument. That was, of course, one answer, which was fine if it worked. And And the other answer was that it was anyway something to do with a transaction between spouses.
Yes. But my Lord, I think the right answer is that they're exempt instruments, but we shall never know
We won't
because it's been settled on the basis that she has no liability.
Right.
In tab 2 of the bundle, we have the accelerated payment notice issued to Mr. Archer. And you'll see on page 8, my Lord, it's it has the appearance of a form, so it shows the amount due, payment date, scheme name, scheme reference, etc. But a lot of this, we can't tell, of course, without other examples of accelerated payment notices, but a lot of this looks like standard rubric. Then, at tab 3, we have the accelerated payment notice issued to Mrs. Archer some 7 weeks later. So the actual notice is at page 15 of the bundle. And your Lordships will see that the scheme reference given is the same, the description of the scheme given is the same, the amount due is slightly different. My Lords, in tab 4, on page 19, we have what we have called the pre-action protocol letter. So I draw your attention in particular to paragraph 2 of this. If on reflection HMRC agrees with our analysis and is willing to withdraw the notices, or using the section 227 power or otherwise, we should be grateful if you'd let us know as soon as possible. Pending that, we intend to proceed to issue the application given that time is running against our clients. Now, so far as I'm aware, there was no response received to that letter. In fact, KPMG issued on the same day, but didn't serve yet. Lords, tab 5, we have Mrs. Archer's witness statement, which contains some factual description of the scheme transactions on page 21 of the bundle.
Is this the same as the witness statement we also find later in the bundle 1 through 5?
I beg your pardon, my Lord, I didn't hear the reference.
I'm sorry, at page 125, sorry, page 56 of the bundle. 56, I think it's the same statement, I just want to be sure we have got 2.
I think that is correct, my Lord, yes.
Yeah, thank you. Yes.
So that was, of course, filed with the judicial review claim form. My Lords, then on the 17th of December, that's to say just within the 90-day period allowed to Mr. Archer for representations, the letter on page 24 of the bundle was sent to the Revenue by way of statutory representations under section 222 in relation to both together. And usually a letter of representations would be, in my experience, 5 or 6 pages of quite closely argued points about whether the various grounds permitting the Revenue to issue an accelerated payment notice arise. But essentially, this enclosed a copy of the claim form and said, see the arguments in the claim form and grounds. as the court sees, our representations are made on the same basis as the application for judicial review. Now,
I proposed a stay of the JR, is that right?
Yeah.
on the second page of the letter, a stay was proposed, which the Revenue did not.
Well, it invites the issue of a closure notice so that Mr. Archer could proceed to the first tier
Yes.
tribunal.
My lord, it may be that is what led in due course to the Revenue issuing the closure notice in July 2015, after the Court of Appeal granted permission for the judicial review. We don't know. Again, these things happen without a great deal of explanation coming. But I wanted to take the court to the sequence of correspondence following these representations, so separately from the judicial review. The reply to that letter of representations is at tab 10 of this bundle. In fact, at tab 10 and tab 11, there are two replies, one for Mrs. Archer and one for Mr. Archer. So the reply came a little over a month later. If you like, it's a holding letter. It says, "Thank you for your letter of 17th of December. Expect to reply within 45 days of the date of this letter." And the court will see that the heading is representations regarding partner payment notice, which is an error, typographic error, presumably. So, in fact, by the time that the Revenue had sent this letter in January 2015, they had already withdrawn the APN in Mrs. Archer's case, because they withdrew it on the 23rd of December. So, at tab 12, KPMG wrote back to the Revenue saying, in Mrs. Archer's case, in paragraph 2, pointing out that the APN has been withdrawn. Then at tab 13, a reply sent in relation to Mr. Archer, in effect reminding the Revenue that there was unanswered correspondence about a stay. So do you see, we after our letter of representations on the 8th of January, we wrote to Mr. Banks of HMRC Solicitor's Office suggesting that one way forward would be for both parties to agree a stay in the JR proceedings, provided HMRC agreed not to confirm the APN until the final resolution of the substantive issue. HMRC forthwith to issue a closure notice to Mr. Archer. The Revenue never accepted that proposal. So the proceedings were never stayed. In fact, what occurred in the proceedings was that Mr. Justice Mitting, in March 2015, refused permission for judicial review, and then Lord Justice Patton in July 2015, this is at tab 18, granted immediate permission for judicial review. In Mr. Archer's case, plainly. But back to the correspondence about the representations. So another letter came for Mr. Archer at tab 14. So apologising for the clerical error. It's unlikely that I shall be able to deal with the representations within the expected time frame, and regrettably I shall have to extend the expected reply date to the 1st of May 2015. Then, tab 16, there's the substantive reply to the representations in his case. And in effect, it doesn't deal with the representations made by reference to the claim form, but the revenue were not in a position to determine that an amount would be payable by Mr. Archer, which is a statutory requirement I'll show you shortly. So they simply say on the third page of this letter at page 75 in the bundle, the amount of the APN is incorrect. I'm satisfied that the APN has been properly calculated. The calculation is not affected as a result of your representations. No further explanation given. Then
do we need to understand what they say about conditions A, B and C?
well, I don't think we do for today's purposes, my lord.
The revenue's position was that they were all met.
All met, yes. But I mean, then page 77, another letter from the Revenue. HMRC regret that inadequate consideration was given to your client's representations. HMRC will not seek to rely on the 14th of April letter, but will consider your client's representations afresh and will give you notice of HMRC's determination once that's been done. Now, they never then, in fact, did that or needed to do that, because before they gave the fresh consideration, the closure notice was issued and Mr. Archer paid. So just to be clear, I'm not seeking the costs of Mr. Archer's claim. I accept that we don't know whether Mr. Archer's claim would have succeeded or not, or we know that it was arguable because this court said it was arguable. But that's all that I can say about that. So back to my submissions, if I may, I'd like to take the court now to the legislation. This is found in the authorities bundle, tab 1. Tab 6, volume 1 of the authorities bundle. So this is the whole of Part 4 of the Finance Act 2014. Provisions relating to accelerated payments start at section 219. So very briefly, in 219, HMRC may give an accelerated payment notice if conditions A to C are met. Note A to C, so they all have to be met. Condition A is that a tax inquiry is in progress or there's been an appeal. Condition B is that the original return or the appeal is on the basis that the asserted advantage results from the chosen arrangements. The chosen arrangements being a tax avoidance scheme and the advantage being the benefit of that scheme. Condition C is that there are various elements of condition C. So the first one is that there's something called a follower notice. I don't know if the court's aware, but Part 4 also introduced provision for follower notices. I'm going to show you a case shortly about follower notices. Follower notices are notices which the revenue can issue at about the same time as an APN, and they in effect preclude rights of appeal if there's been another tribunal case or higher case which in the revenue's view has determined the merits of the scheme already. So they're designed to prevent hundreds of taxpayers from litigating the same scheme in the hope that one of them will succeed. And the way a follower notice operates is that it imposes a penalty on the taxpayer who continues to litigate after the follower notice has been issued and fails. So if the taxpayer succeeds, then it goes away. But the follower notice also has the effect of entitling the revenue in every case where a follower notice is issued also to issue an APN if conditions A and B are met, as they presumably will be.
Well, it's common sense, isn't it?
Yes. Yes. So they,
But we're not concerned with
we're
that.
not concerned with the following notice.
We're concerned
here.
with B, aren't we?
We
General
are.
arrangements of DOTAS arrangements.
We are. So the revenue have only ever asserted that B applied in both Mr. and Mrs. Archer's case. And in Mr. Archer's case, it's accepted broadly. There were some wrinkles and some challenges in his case which are not relevant for today's purposes. But there was a DOTAS disclosure made in relation to the certificates of deposit scheme, and he provided the DOTAS scheme number on his tax return. Mrs. Archer didn't, because she, certainly on my case, wasn't claiming a tax advantage as a result of it. I mean, the revenue, as Lord Justice Henderson has pointed out, the revenue had a case that she had exposed herself to a tax liability by participating in it, but she hadn't gained any particular benefit or tax benefit from it. It was he who was seeking to create a loss to offset against other tax charges that he had.
But if arguably the other conditions were satisfied in relation to Mrs. Archer, you'd accept, would you, that these, the mere fact that they hadn't assigned a different reference number wouldn't preclude them from saying that condition C was satisfied in view of the definition of DOTAS arrangements in subsection 5, notifiable arrangements to which the HMRC has allocated a reference number in section 311.
Well, my Lord, I think it would be condition B that I would be primarily challenging were this a live issue.
Well, I understand that, but I'm simply
So,
asking you whether, if contrary to your primary argument, condition B was arguably satisfied in relation to her,
yes. Well,
then
well,
goes back to the point my Lord Justice Henderson put to you earlier, as to whether arguably they both
yes.
procured a tax advantage.
Well, it does, my Lord. I mean, I think it would depend on. So what's not said in the definition of DOTAS arrangements in subsection 5 is by whom they're notifiable. In my submission, they would not have been notifiable by her.
Okay.
In the same way that they weren't notifiable by the bank. The counterparties don't have the obligation to notify them. The person seeking the tax advantage has the obligation to notify. So I don't think it's clear cut that she was a person meeting condition, or a person in relation to whom condition C was met.
But your main point is on B, that the tax advantage doesn't result from the scheme.
Well,
is that right?
my Lord, I would put it this way, that the main point is on section 220, subsection 4.
Well, what about conditions A, B and C?
She did also say that conditions A, B and C were not met in her case, but the real force of the judicial review was that because the revenue had issued both notices to both spouses, the revenue could not satisfy section 224 in relation to either of the spouses.
Yes, and that gives rise to the point I was debating with you about whether these were truly alternative claims, or whether it was a matter of legal analysis, at least in theory. You have two separate taxpayers, each arguably liable for a different amount of tax.
Well, my Lord, I accept that arguably they are liable, but arguably is not. I haven't made these points yet, but arguably is not the test.
It's a higher threshold.
It's a much higher threshold, yes. And I'll show you two recent Court of Appeal authorities about the threshold in just a moment. Just for your note, the cases are called Rowe and Hayworth. So, in my submission, the primary challenge and the basis of the core of the judicial review was that section 224 wasn't met. So Section 222, the notice must specify various things. And it must specify in 2B the payment required to be made under Section 223. Then in 223, the payment required to be made under Section 223 is an amount equal to the amount which a designated HMRC officer determines to the best of that officer's information and belief as the understated tax. The understated tax means the additional amount that would be due and payable in respect of tax if in case B, such adjustments are made as required to counteract what the designated officer determines to the best of that officer's information and belief as the denied advantage as relating to dotus. Now, in this and other cases, taxpayers are fastened on the word would at the start of 220 subsection 4. That is what I say gives rise to the high threshold. So in a nutshell, the claim form argued that the revenue could not have been satisfied of that in either Mr. Archer's case or Mrs. Archer's case. And that was revealed by the fact that they'd issued APNs to both. That was the basis on which it was put, one of the bases. There were also challenges to grounds A, B, and C, of course, because you're going to put everything in your pleading.
Yes.
And those points may or may not have been good. So that's the legislation. Now, in my skeleton argument, I referred to a number of cases that there have been about accelerated payment notices. So there's a list of them in paragraph 19 of my skeleton. The only ones of these I'm going to take the court to are Rowe and Wallaboo, but I will take you to a new one, which is Hayworth. So if I could hand up copies of Hayworth.
Thank you.
I'll come to Hayworth last, but your Lordship will see that it's a judgment of the 1st of May 2019, and that is why it's not in the authorities bundle, which was prepared already in preparation by that date. So if I could start with Rowe, if it please the court. So Rowe is in the authorities bundle volume 2. Indeed, all of my authorities but one are now going to be in volume 2 of the authorities bundle. Tab 25.
Yes.
So, in fact, it was an appeal in both the Rowe and the Vital Nut case together. The judgment of the court was given by Lady Justice Arden, as she then was. And I rely on paragraphs 61 to 63 on page 482 of this report.
Do you want to read those, or?
My Lord, I'd be most grateful.
Yeah, all right. positively satisfied, is that it?
My Lord, in this authority, positively satisfied and also reasonable grounds for concluding that the tax would ultimately be found to be payable.
Yes.
Now, I think that Hayworth goes even further than this. So in Hayworth,
Mr. Justice Charles at first instance had put it as no more than a negative, hadn't he?
yes,
Paragraph 11.
indeed so.
That it was he was not satisfied that the claim tax advantage was lawfully available,
Yes,
And that's
and
the point.
that would
which
be
means that the
similar.
burden is then on the taxpayer, and that's
Yes.
the point Lady Justice Arden is making.
Yes,
That's
but I think
too
she's also building in some additional protections. I mean, she sees it as a threshold, significant threshold that revenue had to pass.
Yeah.
My Lord, just
Well, it's your point is that
if I could just say, my Lord, I don't just as a reminder to your Lordship, in tax appeals, the case is always that the burden of proof is on the taxpayer. So the taxpayer receives an assessment.
yeah.
The taxpayer has.
But
to
that's a
prove-
different. The point that she's making is if you have a right to an accelerated payment under the statute, if the revenue has a right to serve an accelerated payment notice.
Yes, which is a harsh provision because
Then-
you're requiring tax
yeah.
in advance
No, I
of
understand.
it being determined.
Yeah.
So, in
A fortiori, really, where there's no right of appeal.
quite so. I mean, if your Lordships take the view that it's unfortunate that there is no right of appeal, and these matters would be much better being addressed by the tax tribunals, I can only agree.
Yeah.
My Lord, in Hayworth,
Yes.
as I say, there's a decision of 2 weeks ago or so. So this is a case about follower notices. That's why I was briefly mentioning the follower notice regime. But there's a similar requirement in the case of a follower notice for the revenue to be satisfied that the prior judgment would determine the position in the subsequent case. And in paragraph 36 of this judgment, would your Lordships read subparagraph 1?
Yeah.
Now, my submission, the same applies to section 220, subsection 4, and the word would there.
Yes.
Now, while you have Hayworth, my Lord, if I could show you
How does that work in practice? More than balance of probabilities, more than a 51% chance.
how's that to be
How
determined.
much more than a 51% chance?
Lordship could say that that's still open for another day. I think I'm right in saying that Hayworth, apart from Shirley Archer's case, Hayworth is the first case where one of these notices has been successfully challenged by way of judicial review. So all of the other cases about APNs today, the taxpayers ultimately failed. So the ones listed in paragraph 19 of my skeleton. Dickinson, it isn't mentioned there, Dickinson went to the Court of Appeal in December 2018 and the Court of Appeal dismissed the appeal and cross-appeal simply upheld the judgments of Mr. Justice Charles in that case. So, but as I say, while we have Hayworth open, if I could take your Lordships to paragraphs 18 to 20 as well, just to see sequence in that case. your Lordships will see from paragraph 17 that the date of the APNs was, and the follower notices, was the 24th of June 2016 in that case. So a little surprising, perhaps a little surprising that the permission for judicial review was granted, given that they were just outside the 3-month time limit. But permission was granted, plainly. And the conclusion of the Court of Appeal here in paragraph 61 is that the appeal was allowed and the follower and APN notices were quashed. Without taking you to it, I think it's common ground that in all of the other cases, Roe, Vital Nut, Wallapoo, and Dickinson, again, the judicial review claim forms in those cases were issued within 3 months of the original APN and without waiting for the representations procedure to complete. So the statutory representations have to be made within 90 days, and in effect, judicial review has to be commenced within 3 months and promptly. So in practice, it's unsurprising that a letter of representations might be sent at about the same time that a claim form is issued. But it takes the revenue, as we've seen, typically at least 45 days to respond to a letter of representations. So in Hayworth, I think it took them about 3 months. In Mr. Archer's case, it took them about 5 months. And then even that response wasn't satisfactory. So in practice, taxpayers do not have any expectation that they will receive a response to representations within the time running for issuing a claim form, if I'm right, that time runs from the date of issue of the APN, and subject to the ability to invite the revenue to agree to not take a timing point.
So far as Mr. Hayworth is concerned, there's nothing here that you've shown us anyway that suggests that he made representations at all.
My Lord, yes, I think the representations are being quoted, are they not, in paragraph 18? So I think he sent.
Oh yeah, sorry, I beg your pardon. You're quite right. They're just not set out. Yes,
I think he sent representations in September and received a response in December, so about 3 months.
Yeah, yeah. But I mean, your point is that they sent the representations and issued the JR at about the same time.
In about the same week, but my real point is that they couldn't wait until December to issue, because December would have been well outside the 3-month period, unless the revenue had agreed to take the time. Now, in terms of the authorities, the other case on which I rely is in tab 17 of volume 2, a case called Cockayne. This is judgment refusing permission for judicial review in the Cockayne case. It's headed draft ruling, but I think that must just be a typo by the time it's reached someone like me. I have no connection with this case. In paragraph 16 of this, I'm afraid the pages are not numbered. Could I invite you to read paragraph 16?
Yes. So this was out of time, whether you took the date of the issue of the PPN or whether you took the exhaustion of section 22.222.
Yes, it was out of time on both bases,
Yeah.
but the reasoning does indicate that and I rely on this, the decision which is under challenge is the one which was reached to issue the PPN, in this case APN in the present case. Now,
You received a decision there affirming the original decision to issue the APN in your case.
in Mr. Archer's case, we received an affirming
No, but if you
decision.
did,
If you
in,
did,
either,
yes.
in either in any case,
Yes.
presumably that can be attacked on exactly the same grounds as the original decision issuing the APN.
Well, my submission is very difficult and uncertain, and your judgment, the court's judgment in this case, may provide guidance as to what should occur. It may be that your lordships won't need to address that, but certainly the judgment below is seen as very interesting guidance on this type of question.
Mrs. Duff does appear to have thought that, as he puts it, the more pragmatic approach is the time ran from the date when the representation process was exhausted and the original decision was either confirmed or varied or whatever.
He does, and as your lordships have put to me this morning, if the revenue will agree to that, I accept that that is a more pragmatic approach.
Well, on one view, if Miss Justice Green was right below, then time would run from the date of exhaustion of the notice, because otherwise the JR can't have been premature, can it?
Well,
the respondents can't have it both ways.
Well, exactly. If they're agreeing to effectively not take a timing point, then that must be on the basis that I'm right, that time runs from the original notice. I'm going to, I hope, develop this and make this good. But in my submission, there's considerable uncertainty as a result of what Ms. Justice Dove said, and in my submission as a result of what Mr. Justice Green has said, which makes a horlicks of it, with respect. The judicial review is a well-defined remedy. It's a remedy of last resort, but is axiomatic that claims have to be brought promptly, and against the decision which is the decision which is actually being challenged, the decision which is actually being impugned, and which you're asking the court to quash. Now, the statutory mechanism, in my submission, gives the revenue the right to issue a single notice, that's to say, the APN. And there are prescribed conditions, A, B, and C for that, which we've just looked at. And then there's a raft of requirements in section 220, which the revenue have to satisfy in order validly to issue the APN. Once they've issued the APN, then a mechanism operates. So the taxpayer has to pay it within 90 days, or can make representations. If the taxpayer makes representations, then the revenue will respond in some manner to those representations in due course, and the taxpayer then has 30 days from the revenue's response within which to pay. Now, it is perhaps worth looking at the statute again. The statute does not appear to give any particular status to the revenue's response. In other words, what I mean by that is that the revenue's response, so I'm referring to section 222 in tab 6. 2221 starts with a standard rubric. I don't know if you can read it clearly, but this section applies when an accelerated payment notice has been given under section 219 and not withdrawn. So that "and not withdrawn" phrase appears throughout this chapter of the Act. P, that's the taxpayer, has 90 days beginning with the day the notice is given to send written representations objecting to the notice on the grounds that condition A, B or C in section 219 was not met, objecting to the amount specified in the notice, or objecting to the amount specified in a different manner. HMRC must consider any representations made in accordance with subsection 2. Having considered the representations, HMRC must determine whether to confirm or withdraw the accelerated payment notice, or if the representations are about the amount, they must determine whether a different amount, and then your lordships see in square brackets, or no amount. Now that was an amendment made to the legislation after Mrs. Archer's case. So that amendment was with effect from March 2015. So under 4B, if representations were made, the revenue must determine whether a different amount ought to have been specified under section 222B, and then confirm the amount or amend the notice to specify a different amount, and so on. So
why is the determination that has to be made under 4A or B? Why is that not a decision which is susceptible to judicial review?
well, it may be, my lord, but in my submission, it's not independently susceptible to judicial review. So if the whole process is misconceived,
But surely, this contemplates, doesn't it? If you look at subsection 4 Roman A1, confirmation of the accelerated payment notice with or without amendment. So it contemplates the possibility that the taxpayer says, well, I don't agree that conditions A, B and C are met for the following reasons. The revenue consider the representations and determine that, for example, that the conditions are met, but for different reasons than the ones they're given in the first place. So you get an amended accelerated payment notice, because that's what this contemplates, that possibility, both in relation, as it were, to liability and quantum. But wouldn't it then be the case that that decision to issue an amended notice would be the decision which was capable of being a separate decision, if you like, which is capable of being the subject of a JR?
well, my lord, certainly if it had something new in it, it would be the new aspect would be susceptible to JR. But in my submission, if it is simply confirming their original decision, as is the common case in practice, then in my submission, the grounds to challenge that, the unlawfulness, arose when the original decision was made. So it can't be a decision which was lawful when made and then it becomes unlawful because it's been confirmed. If it was unlawful all the time.
Yep, understood.
And the confirmation of it, in a sense, is the opposite of refusal to withdraw it. Is the opposite of withdrawal. It's, in other words, a refusal to withdraw. It's a steady as she goes approach, and it doesn't change anything. Nothing new has happened in effect.
In a sense, doesn't that rather beg the question? And what has changed is that there's been a statutory process of representations which have been made and considered, followed by a decision to uphold the original notice without alteration. It's another way of just stating what has happened. But surely in that situation, it is the restated and reaffirmed notice which is the one that matters, because now that the statutory machinery has been exhausted, and the only possible challenge left is via JR.
As a matter of last resort.
As a matter of last resort. That surely is the classic role of JRs that come into play when nothing else is available to check unlawful behaviour.
If the statutory mechanism is a remedy at all, which I'll come to, but But in my submission,
Well, it looks quite like a remedy if it can result in a withdrawal of the APN.
but there's no, the taxpayer has no power in it. The taxpayer has no legal right that the revenue will take these steps, other than public law.
Well, you say other than, but I mean, HMRC are under a statutory duty to consider the representations and then to do one of the specified things, including confirming or withdrawing the notice and confirming or amending the amount payable.
Yes, but I mean, if the revenue, as in practice in my submission, is likely confirm their original notice. I mean, unless there's been some obvious error in it or something obviously wrong with it. If they do that, you know, that's their exercise of discretion in doing so. The taxpayer's not. The taxpayer can make the representations, but there's no compulsion on the revenue. The revenue, and if the revenue confirmed the original notice, they're effectively saying our original decision was right. And then, assuming that they hadn't agreed to waive time limits, wouldn't the taxpayer be at risk there of the court saying, well, you haven't brought your claim within time because the true challenge, the true basis of your challenge is to the original decision to issue this? I mean, it isn't the original.
It comes back to your point, which you make, as it were, in your skeleton as your fallback position, and I don't mean that in an offensive sense. That even as it were, if you're wrong, generally on your appeal, that actually this is an area which requires clarification by the court, and if the court were to say, picking up on my Lord's point, that actually what the decision which is capable of being JR'd is a decision that's made after the representation process has been gone through, then that would resolve any doubt, would it not, about when time began for the purposes of JR.
For the future, indeed.
For the future, yes.
Indeed.
Then you say Mrs. Archer didn't have the benefit of the guidance that we're about to give, and therefore she was entirely justified in bringing her JR against the original decision.
I do say
Yep.
that, and I find
Thought you
support
said
for that in the approach taken in all the other cases. So it's, I mean, the thing is, if I'm wrong that the original decision is the decision which it should be challenged in judicial review, and if the revenue are right to say that the statutory machinery provides a remedy until it's been exhausted at least, then why wasn't that point taken in any of these other cases? Why were these other cases permitted to proceed when this alternative remedy was sitting there? I mean, and you know, proceeded.
Well, because all the other JRs have failed, with the exception of Horth.
Well, well,
so the revenue's never had to argue that.
But this is a permission point. I mean, if the revenue have a good point here, they would raise it at the permission stage. The aspect which is truly being challenged here is the exercise of a power under section 220 to determine the amount in the APN. And that power, in the present case, that power was exercised when the APNs were issued. And I accept that the revenue could have, in effect, changed their minds about that, pursuant to representations, but they could have changed their minds without representations. I mean, you could have just written them a letter saying, the exercise of the power is inappropriate here, as indeed we did on the 28th of November 2014. But once that power has been exercised, you have the statutory notice, and then all of these other mechanisms come into play, including the right to make representations. And what we're saying is we shouldn't even have needed to make representations about it. It wasn't a valid notice in the first place. It was unlawfully issued.
Yes, but the machinery for the representations I mean, clearly envisages that the notice may be one which, in your language, was, so to speak, an improper one from the beginning, because after all, it provides for the notice to be withdrawn when the representations have been considered.
Well, my lord, it does. It does within the scope of Section 222. So.
But I mean, in a context where there is no statutory right of appeal, which is a controversial feature that we have to accept as Parliament's wish in this context, surely one, if anything, I should encourage one to give a fairly generous interpretation of the provision which is made for challenging the notice by means of what Parliament must have thought one would imagine to be the appropriate procedure, namely making representations, consideration of them, and a response within what is conceded has to be a reasonable time frame.
Well, in my submission, if the objection, the true objection to the notice is that it wasn't validly issued, not only on the basis that condition A, B and C were not met, but on the more fundamental basis that the revenue couldn't exercise the power of determination to the best of their judgment under Section 220, subsections 3 and 4, there isn't an express reference to that in Section 222. Now, below, Mr. Justice Green held that it's B here, objecting to the amount specified under 222B, that implicit within the objection to the amount are all the points that a taxpayer might want to make about validity. And in my submission, that's putting it putting it much too high. That's attributing much too much to representations about the amount. Before the 2015 amendment to this, in my submission, the mechanism simply contemplated that there might be an error of some kind in the amount, some sort of calculation error or something, and so there was provision for a different amount to be included in the notice by amendment. But
well, one may question whether the amendment was actually necessary or whether it just spelled out what was anyway implicit. I mean, why is 0 not a different amount?
yes, well, mathematically 0 is an amount, but not a very large amount. But
it would seem a hyper-technical argument that one couldn't have reduced the notice to nothing if one thought it was misconceived, merely because the statutory language just talks about amending the notice to specify a different amount.
But some of these judicial review challenges are on bases that have nothing to do with the amount in the notice at all, but on human rights challenges and due process, this sort of challenge.
I'm not clear that we're in that kind of territory here.
I suppose you might say that not just the word amount, but it says a different amount ought to have been specified under Section 222B, and that would be nonsense if it was 0, because an APN specifying 0 would not make any sense at all.
Yes. Any payment required pursuant to it, presumably. Yes, I mean it is a little bit peculiar, but we.
But your point really is that in the light of what is determined by the authorities such as Roe, the obligation in Section 220, subsection 4, which is imposed upon the HMRC officer, is not. If you want to challenge that, then there's nothing in Section 222 which at least explicitly deals with that right of challenge by way of representations.
Yes, well, in particular, if your challenge is based on extraneous material, so here, in this case, the fact that there was also an APN issued to Mr. Arch.
Yeah.
So if there hadn't been both APNs, then the challenge would have been on a different footing. And my submission I'm not sure whether it's a process. It's not a due process challenge as such, but it's a rationality challenge to the, in effect, not to the assessment mechanism used by the revenue. I'm not saying the revenue didn't determine the £6.1 million figure that we saw earlier in a correct manner. What we're saying is that it was the decision to issue the APN which was irrational. Revenue should not have issued both APNs together. Somebody decided that that's what they were going to do, though. And it's, as I said in the claim form, we think it was done in order to bring pressure to bear on the taxpayers to settle. It was like, you know, wave a big stick, there's a £12 million potential tax that you'll have to pay if you don't reach the settlement that we've offered you. But these matters will now never be determined because although Lord Justice Patton gave permission,
Yes.
so these would have been aspects of Mr. Archer's challenge, etc. But so I need to deal with Glencore, but if I could just come back to my skeleton argument. So the as I say, my submission, it's in reality, the challenge here was a challenge to the issue of the APN, and not to subsequent steps that may or may not have been taken. And that properly, subject to the potential for the revenue to agree some other course, that properly was a challenge which had to be brought by reference to the issue of the original APN. The statutory representations are not an adequate remedy in substitution for judicial review. In other words, you can't simply say there should be no judicial review because there's been a statutory route and any remedy the taxpayer was entitled to, the revenue would have had to have given under Section 222. So in other words, you can't say that because 222 exists, you can never bring judicial review. I mean, the courts...
Nobody is suggesting that.
No.
It's a question of when you should be able to bring your judicial review.
Yes, but my lord, the logical process leading to that does throw into question what it is that's being reviewed. So if your lordships are of the view that 222 is a mechanism for redress, which needs to be exhausted first in all cases, if that's your lordship's view, then that would imply that the only aspect that can then be subject to judicial review is the confirmation decision. And that seems to me to be potentially dangerous, because what if the confirmation decision is reached lawfully or rationally, but somehow the original decision wasn't? Difficult to think of an exact example how that could arise, but I'm sure there must be one.
Well, you could be out of time to under Section 222, so the revenue could say, well, you're out of time, and therefore you're not entitled to challenge it down this route. Then you'd be out of time for JR and out of time on. You'd have two perfectly lawful decisions from the revenue.
Yes, I mean, I suppose you in those circumstances, I mean, you could apply to the court to extend time, but in an unattractive case for that. But maybe there's some good reason, like
but if it
wasn't served on you in a timely manner or something like that. But in a normal sort of case, I mean, the confirmation decision, as we've seen, I mean, we've seen one example of a confirmation decision, albeit the revenue subsequently accepted that it was inadequate. We've seen one example. It doesn't have much meat to it. It just, in effect, says, I don't accept your representations. I think the original decision was valid. And
that may just reflect the facts of this particular case. I mean, what we have to work out is what is actually envisaged by the revenue take the representation seriously.
Yes,
So
of course.
Duty to do so.
Yes.
And to respond to them. So whether they respond at length or not will surely depend on the facts of the particular case and the representations which are made.
Yes, but if the response confirms the original APN and then you're challenging them in judicial review, what are you challenging?
Well, it seems to me, at the moment, I can't see what the difficulty is in saying you're challenging the confirmatory decision after the procedure laid down in section 222 has been exhausted.
That would have to be, it seems to me a difficult case, that would have to be on the basis that the confirmation decision has read into it all of the requirements of the statute in section 219 and 220. So, I mean, there isn't, for example, my lord, there is...
You can only confirm a decision by having reference to the criteria which originally had to be applied in the first place. But
Well, I'm not sure not sure about that, my lord. I think that would be a difficult case. So, for example, particularly the requirement to make the determination to the best of the officer's judgment, the designated officer. So there has to be a designated officer in 220. It doesn't have to be a designated officer to make the confirmatory decision in 222. It doesn't say who's going to do that.
The confirmatory decision is going to be adopting the reasoning of the original decision.
Well,
saying it's right, and that therefore if the original decision was wrong in some respect and it's adopted on the confirmation, then the confirmation is wrong for exactly the same reason.
Well, but in that case, my lord, I think that the doctrine in judicial review is that the review should have been brought against the original decision. So the confirmatory decision isn't new.
Well,
in other words,
satisfy me of that.
Well, because
decisions are decisions.
If
Because
the
the original-
confirmatory decision is made after the revenue has gone through the process, which, as my Lord Justice Henderson says, it is under a duty to do so, set out in section 222 of considering the representations and determining whether or not, in the light of the representations, its original decision needs to be varied in some way.
well, my lord, it isn't newly unlawful. So the unlawfulness, it's confirming an existing unlawful decision, but the unlawfulness has already arisen if there's something wrong with it.
But
So-
this can't be the first occasion that this question has arisen in any area. It must. I mean, there must be internal review procedures which have to take their course,
Well,
and the courts must have expressed a view about whether you can attack the confirmation or the decision.
well, my learned friend's going to show you a planning case.
Yeah.
But in my submission, in each statutory area, there are subtle differences in the position. So in the planning case, a judicial review claim was premature because they challenged, in effect, what amounted to a statement of intent rather than a grant of planning permission. That was premature. Below, there's some discussion of a case called Said about higher education appeals and challenges to decisions made by higher education authorities. And the position there is that there is a non-judicial sort of ombudsman type process for appeal, which creates a non-binding decision, but then in practice usually the parties adopt it. But that has been held to be a form of ADR that can be pursued in parallel to judicial review, but it isn't a satisfactory alternative remedy because it isn't binding.
I'm sure you're right. These cases will all turn on a particular statutory context, but at the moment, striking features of the context we have here seem to be that, firstly, very unusually in a tax context, there is no statutory right of appeal. And given that highly unusual feature, one then looks to see if Parliament has provided any alternative means of potential redress. And what do we find? Section 222, which is an integral part very inception. So if one's looking to objectively deduce the intention of Parliament, I'm inclined at the moment to think Parliament must have intended that machinery should have been used in any case where it properly could be, and that one has to await the outcome of that process before JR enters the scene.
Well,
That's leaving aside cases where JR is the only potential remedy, and I can see there might be a different category, but as I say, I'm doubtful whether we're in that kind of territory here, although I take your point about the involvement of the separate notice served on Mr.
Yes.
Archer.
Well, my Lord, in my submission, of course, there's a range of cases. So at one extreme, there's a perfectly ordinary case where there's some calculation error or typographic error in the statement of the amount, and that plainly would be a matter to be dealt with under this machinery. But it probably wouldn't be a case where the taxpayer had any public law right. I don't see this the court being very interested if the taxpayer's claim is based on there being transcription error in an amount or something like that. There are going to be cases where, for some reason, the taxpayer has a valid argument that condition A, B, or C is not met, and I don't shy away from saying that Mrs. Archer did have a valid argument to that effect as part of her claim here, but that's not the sole basis of her claim. And it's plain from the statute that if it's a challenge to condition A, B, or C, that is a matter for about which representations can be made. If I can call those cases 1 and 2, I'm going to skip 3 for the moment. Case 4 is a case where there's a pure public law, human rights type of challenge, perhaps a due process challenge to the issue of the APN. Dickinson, the taxpayers had quite a solid case based on due process or legitimate expectation. I mean, they didn't win, but the revenue didn't succeed in getting costs in that case because there was some prima facie problem with the process that had been followed. So in my submission, in a pure public law case, the statutory mechanism in 222 is not going to be appropriate, but I think it's important to ask why. Why isn't it appropriate? And the reason is that as I've submitted already, presumably in that case the revenue would confirm their original decision. Otherwise there wouldn't be anything to argue about. But if they do confirm it, the unlawfulness is not, or certainly is not solely in the confirmation decision. The unlawfulness arose when the original decision was made, and that is what the taxpayer seeks to challenge in the judicial review.
But isn't the core of your argument as to why it's unlawful and why you say it was unlawful to issue 2 APNs demanding in effect £12 million rather than £6 million, that you say that on the facts of this case, condition B couldn't be satisfied in relation to both the taxpayers. It had to be one or the other, and the revenue got it wrong.
My Lord, certainly in Mrs. Archer's case, one of her arguments is that condition B couldn't be satisfied in her case.
Yeah.
But the core challenge was that the tax would be payable requirement in section 220, subsection 4, could not be met in both cases.
Doesn't the one follow from the other? It was a point that my Lord Justice Henderson put to the beginning of the hearing, that I mean, if condition B was arguably satisfied, subject to the point, the 51% point we discussed a moment ago, then you'd be on much less firm ground. I mean, the real basis for saying, well, they couldn't be satisfied as to would in section 220, subsection 4, was that they just couldn't conclude, or shouldn't have concluded, that condition B was satisfied for Mrs. Archer, because only one of them had obtained a tax advantage.
well, that's certainly an argument. Well, I mean, in Mrs. Archer's case, her argument was that she had not obtained a tax advantage at all. But the basis of the claim, the basis of the judicial review claim, the joint claim, was that the revenue had expressly or otherwise shown uncertainty as to which taxpayer was chargeable, but accepted, maybe not as a true alternative, but accepted that in practice they would only seek tax from one or the other. And as such, the revenue themselves cannot have been, as an internal matter, the revenue cannot have been satisfied in both cases that tax would be payable by that taxpayer. And they couldn't, I mean, it was in a sense a challenge to the process. It was a challenge to the use of APNs in those circumstances to demand £12 million when really the revenue's position was that it was one or the other in the alternative. They would accept that. So, that's why it was obviously unjust, why unfair, perhaps is a better word, for them to do that. And that's why, in my submission, they rightly conceded the judicial review in Mrs. Archer's case. Look, in the judgment below,
Yes.
I apologise. In the judgment below, there's this is in tab 11 of the core bundle. So in paragraph 35, there's a summary of submissions I made there. On why representations are not of themselves a satisfactory alternative remedy to judicial review. And could I ask your lordships to read from in oral submissions in the 6th line here, for about 8 lines.
One way or another, you've made all those points to us.
I hope I have. But it's a helpful summary.
Thank you.
So just to recap, I think the logic is that if the representations route is a suitable remedy, then that would imply that there cannot be a judicial review against the original decision. There can only be a judicial review against the confirmatory decision under the representations route, which would be a different, challenge. I mean, you could say it would be a challenge against both the original decision and the confirmatory decision. But in my submission, there isn't in judicial review available normally an approach where you're challenging the original decision but waiting until a later stage before you're allowed to bring that challenge. And in effect, Mr. Justice Dove addressed that in the passage we've looked at, where he said that what you're doing is you're challenging the original decision, but it would be expedient or sensible to wait. But the logic of it is, in my submission, difficult. What are you challenging? Are you challenging the review decision, or are you challenging the original decision? If you're challenging the review decision, you may be out of time if the basis for that is that the officer, when they made the original decision, didn't make the decision to the best of their judgment, or didn't follow 2220 in some other way. I think I'm starting to repeat myself. Can I briefly turn to Glencore? This is in the Authorities Bundle, tab 25, bottom 2.
Yes.
Sorry. 24. So this case features strongly in the judgment below, and without any disrespect, I think one of the reasons for that was that the first instance decision in Glencore had been a decision of the same Judge Mr. Justice Green. So it was much in his mind when he gave judgment, when he heard our case and gave judgment in our case. He describes the Glencore statutory framework as similar to the APN process. The statutory framework is described starting at paragraph 8 of the Court of Appeals judgment. To save your Lordship's reading all of that, if I can just explain it. It's about a newly introduced tax called DPT, which means diverted profits tax. It's a type of, it's an aspect of corporation tax. It's payable by large groups of companies where it can be shown that they've, broadly speaking, arranged their affairs in the type of way that the newspapers object to in cases like Amazon, Apple, those sort of cases where, in effect, they have operations in more than one country, and they have put operations which are essential to their business in the UK in some other country where there's very little tax to pay. And then they say, well, in the UK we're not making very much profit because we have to pay an awful lot to our subsidiary company in this other jurisdiction for these market value products. And that's regarded as a diversion of taxable activities into a different jurisdiction in very broad terms. Now, as it says, to divert profits which would otherwise have been subject to corporation tax in the UK away from the UK to low tax jurisdictions. I'm reading from paragraph 8. And where the revenue believe that to have occurred, they issue a notice charging the diverted profit tax for the period of assessment, and there's then a automatic statutory process whereby there's a 12-month period within which that the amount of that can be reviewed and the party can make representations and the revenue have to consider them and so on. And at the end of the 12-month period, the revenue confirm or revise the amount of the assessment, and then the taxpayer has a right of appeal against the confirmation of it. And so I think it would be fair to describe in that case the amount of the DPT as being inchoate until the 12-month statutory representations period has been...
Which is called a preliminary notice as well, which gives substance to that.
It would indicate that it isn't intended to be of immediate effect. But of course it does trigger the machinery. But in my submission, it is a different type of machinery. The fundamental difference is that there is an appeal mechanism at the end of it, whereas in the APN case, of course, as we know, there is no appeal mechanism. And
well, where there's an appeal mechanism, you can see that there is, on the face of it, inadequate alternative remedy.
yes,
And there was obviously an issue about the waiting period, the 12-month period. But I think the point that's made is really it's like a form of mediation, if you like. Before you can appeal, you have to have gone through that process.
Yes,
And
exactly.
you'd accept that if Section 222 involved at the end of the day an appeal process, then you would say you would have to accept that the similarity that this Justice Green drew would be there. But you say there isn't a similarity here because there is no appeal process.
Yes, I say it all turns on whether there's an appeal process or not. And just for your note, my lord, to make that good, I rely in particular on paragraph 57,
Yes.
60 and 61 for the introduction to Lord Justice Sales as he then was. So they make it clear that it's really the existence of the appeal mechanism. But
Now, when it comes in 65 to 67 to deal with the review, it's in the sense of, does the existence of a review interfere with the scheme as a whole being regarded
Yes.
as a suitable alternative remedy?
yes,
Not whether the representations review is in itself a suitable.
precisely. Your lordship puts it better than I would. But in tax, there's no. It's not strange that tax might be payable in advance of an appeal. So there are. I wouldn't say it's commonplace, but there are plenty of areas in tax where, if you like, the holding position pending an appeal is that the tax is payable. So in particular in VAT, if there's going to be a VAT appeal, the default position is that the taxpayer has to pay the VAT that's in issue before they're entitled to proceed to an appeal in the tribunal, unless they can establish that that would cause undue hardship. And in where there's been an assessment, then similarly tax is payable pursuant to the assessment, even though it's an appealed, unless the revenue or the first tier tribunal agree to postpone the tax that's been assessed. And we have the machinery for that in I think tab 1 of the authorities bundle. It's section 55. This has reminded me that I've forgotten to make my best point.
Just wondering, it's at the moment sounding like a bit of a deviation, but now that you've said that, we're going to look at it.
So section 55 is the as I say, is the machinery that provides the tax to be payable when it's assessed, even though there's an appeal. And that particularly arises from subsection 2. Tax charged by the assessment shall be due and payable as if there'd been no appeal. Then, under subsection 3, if you believe you've been overcharged, you can, the taxpayer, can apply for postponement of the amount that's overcharged. So in effect, let's say there's an appeal where only half of the assessment is in issue and half is accepted, then the half that's accepted would still be payable. So you would only postpone the part that's in issue. And there's a mechanism for that, has to be done within 30 days, etc. Now, crucially, and I do apologise, I forgot to make this point before, where an APN has been issued, the taxpayer who then appeals an assessment is not entitled to postponement. And that is the effect of subsection 8b on the second page of this. So where a person has been given an accelerated payment notice or part in payment notice and that notice has not been withdrawn, then subsections 8c and 8d apply, and particularly 8c, nothing in the section enables the postponement of tax to the extent that it's the payment specified in the notice or the disputed tax specified in the notice. Now, your Lordship sort of seen that this applies where a person has been given an accelerated payment notice. So it will apply immediately when the accelerated payment notice has been issued. And in practice, this is a very important consequence of APNs in any case where there is an appeal. Now, I accept that in my client's case there wasn't yet an appeal, but if in due course the revenue issues a closure notice and she appeals, let's say Mr. Archer was issued with the closure notice in July 2015. If he'd appealed that instead of simply paying it, then the effect of the issue of the APN to him immediately, regardless of the representation's position, would have been that he would have been unable to postpone the tax, so he would have had to pay within 30 days of the closure notice or the assessment, as the case may be. Your Lordship sort of have no difficulty in seeing that that's very important to taxpayers in practice, and I anticipate the question will be, well, what's the status of 8B in a case where a taxpayer makes representations and in due course revenue accept the representations and withdraw the APN. Now, I don't know what would happen in that situation. I think it might depend on the timing, but so let's say that in July 2015, so the revenue haven't yet responded satisfactorily to the representations. They've written a letter that we've seen in May saying we're going to reconsider your representations and give you another decision in due course. So we're still waiting for a decision. Mr. Archer was issued with a closure notice in July. He had to pay that within 30 days because Section 8B and 8C, sorry, 55, 8B and 8C applied to him. What would have been the position if then, let's say in October 2015, the revenue had said, oh, well, actually we accept all your points and we withdraw the APN at this stage? I don't know what the position would be. I mean, he would have already paid the revenue by that stage. There isn't a statutory mechanism to recover from an amount that you've paid pursuant to Section 55 while you still have an appeal pending that hasn't yet been determined. I think the position would simply be that tough luck, he's had to pay because there was an APN at the time the closure notice came. So,
well, I mean, in that situation, the revenue then would presumably not pursue and they would then concede the appeal.
Well, no. They might say that the APN couldn't have been issued to him because the condition wasn't met or they weren't sufficiently meet the greater than 51% threshold, but they might still have wanted to pursue the appeal. So there's a range of possibilities. I'm simply exploring very hypothetically what the possibilities would be.
But this regime you've just shown us in 8B, subsections 8B to 8D, is designed to presumably to deal with the, in a sense, it's part and parcel of the rationale for the APNs in the first place. That where the APN isn't withdrawn, the mere fact that there's then a closure notice, which gives a right of appeal, doesn't entitle the taxpayer to then apply to the tribunal for a postponement of the tax, because he's had to pay pursuant to the accelerated payment notice.
Well, it's a little bit odd to divine Parliament's intention here, because the payment pursuant to the accelerated payment notice is not tax, as Lady Justice Arden explained in Roe. It is the payment on account.
It's payment on account, yeah.
But what you pay pursuant to the assessment is tax, and so once you've paid pursuant to the assessment, in effect, the APN is spent or it's irrelevant. So when you've paid the true tax pursuant to the assessment.
Well, that's a different point, though, isn't it? I was simply putting to you the point that where there's then a closure notice and the taxpayer appeals,
Yes.
these subsections ensure that the taxpayer can't then apply to the tribunal effectively to postpone.
Well, for consistency,
Any-
I see that, Muddle, but I'm just saying it is a little bit odd because, in a sense, if you've already paid on account.
Well, I can see that point as well, that in fact applying for postponements is pretty fruitless because you've already paid up front.
Yes, exactly. But I can see it might have an effect on the interest calculation or something like that.
Okay.
But
Okay.
Be that as it may, the immediate effect of the issue of the APN is that you're not entitled to postponement. The immediate effect, regardless of, I mean, the payment on account pursuant to the APN, you might not be paying for, let's say, 12 months. So if we look at Mr. Archer's time frame, he was issued with his APN in September 2014. In May 2015, the Revenue still hadn't made a decision on representations because they said we will withdraw our first decision, we didn't get it right. So let's say that they gave a decision in August, he would then have had 30 days to pay. So effectively he makes his payment on account a year after being issued with the APN. Meanwhile, all sorts of things could have happened. But in practice, 8B and 8C are very important. So to a taxpayer who's potentially going to appeal, they have the immediate effect that you have to pay. And it follows, in my submission, that is a reason why the APN, when it's issued, has an immediate legal effect, which the taxpayer is entitled to challenge by way of judicial review, rather than waiting for the representations procedure to conclude. Now, look, I think, if I can just take instructions, but I think that may conclude my sentence. I'm grateful.
Thank you very much, Mr. McDonald. Yes, Mr. Yates.
The way I'd like to structure my submissions is I'd like to go very briefly over the facts again, just draw out a couple of points. I'd then like to take you through the three cases I really want to focus on, which are Cowell, which was the case cited by the learned master, Burkitt, which is the House of Lords planning case, and then finally Glencore again. Before making some comments on discretion. The Revenue's case in this appeal is that, first of all, the learned master did not err in identifying that section 222 was an alternative remedy which Mrs. Archer ought to have used prior to commencing judicial review. But we say in the alternative, and in any event, the learned master was entitled, as a matter of discretion, to make no order as to costs, bearing in mind the failure to use both section 222 and, more generally, the pre-action protocol itself. Fundamentally, we say that the analysis of alternative remedy is really an analysis on when the High Court, as a matter of discretion, ought to exercise its inherent jurisdiction. And that exercise of discretion follows certain principles, in particular that judicial review should be a remedy of last resort. Now, in some cases, and Glencore is a good example of this, it's clear that the court will not exercise its jurisdiction save in exceptional circumstances. And so the classic example of that is where there is a statutory right of appeal. And that is so even if such a right of appeal is not in fact exercised. That's quite clear from some of the authorities. However, in other cases, the discretion is potentially more flexible. The case law is consistent on this point, however, that the parties must seek, if at all possible, to resolve or narrow their dispute before initiating judicial review proceedings. That is plain from the Cowell case, which was cited by the learned master in his decision, and is echoed now in the pre-action protocol for judicial review itself, which explains in relatively layman's terms that you have got to exhaust both an alternative remedy and ideally any complaints mechanism if available to you. Now HMRC say this was plainly not followed here. There was an inexcusable failure on the part of Mrs. Archer and those advising her to engage either in the pre-action protocol or to engage with the Section 222 mechanism, which we will see, and I don't think is really disputed, is part and parcel of the APN regime itself. And ultimately we say, whether you agree with Mr. Justice Green, as he then was, that Section 222 is an alternative remedy, which needed to be exhausted, or whether you just take a general approach as to what the correct order ought to be, there can't be any doubt that the correct order is that no order on costs was the right one to be given. So with that introduction, I'm very grateful to my learned friend for having taken you through the APN legislation. I don't propose to go over that again. So if I may, if we could just draw up Authorities Bundle 1, tab 10, and go to CAL itself. I'm taking CAL first and then going to the facts because I think it's worth just reading what Lord Wolf said in this case before then looking at what the communications were. So if we have tab 10 up, this is CAL, and if I could just ask you to read paragraphs 1 to 3 by way of introduction,
Yes.
and then we'll take it from there. And just by way of opening, what that passage shows is that what Lord Wolf is envisaging is not alternative remedy in perhaps some strict or narrow sense, but the full panoply of potential alternative dispute resolution, whether set out in a statutory mechanism or otherwise. For a description of the complaints mechanism at issue in that case, you can see that set out in paragraph 9. I'm not proposing to go through it at length, but if one turns over the page to the report at 805, you can see there's essentially a panel, but crucially, it's not binding on the local authority.
Yeah.
And if I could then just take you on to paragraph 14, there is essentially a dispute about what was said before the judge, that is Mr. Justice Harrison, as to whether a stay ought to have been given to allow the complaints mechanism to proceed. We don't have to get involved into that. What we see at paragraph 14 is a general comment by Lord Wolf as to why things have gone wrong, and if I could just ask you to read that. And so Lord Wolf is lamenting the mistake the parties fell into in that case. And we would submit that that is the mistake Mrs. Archer fell into in this case. Even if you were to accept all of what my learned friend has said about alternative remedy, and if one takes a purist stance to it and how satisfied one can be with it, that does not automatically follow, therefore, that you have the automatic right to have your without engaging with any mechanism.
He's really making 2
Yeah.
points, isn't he? The adequate alternative remedy is quite often something which actually precludes judicial review altogether.
Indeed.
And as you rightly say, even if you there's an appeal mechanism and you choose not to employ it, you can't then try to avoid having failed to employ it by seeking to judicially review. Well, that's one category of case, if you like, a sort of absolute bar. But what Lord Wolfe is talking about is where you've got other perhaps less formal or less absolute rights of resolution of one kind or another. You've got to go through those before you should be entitled to judicial review, or at least show a compelling reason why you shouldn't have to go through them.
Indeed, my lord, and I in my skeleton I tried to set up that dichotomy as well, where you have the, save in exceptional circumstances, you're never ever going to have a judicial review. See Glencore, for example. And in other cases where the courts talk about exhausting your alternative remedy or some other mechanism before then launching a judicial review. And then you can see how Lord Wolfe then engages at 15 with what the claimants say about why the complaint procedure is not a suitable alternative remedy. And what you will see is that issue ultimately doesn't get resolved, and it wasn't resolved by Mr. Justice Scott Baker, as he then was below, either in this case, because ultimately what the court is really addressing is the failure to engage with whatever mechanism you do have in front of you, and seeking to avoid litigation at all costs. So the reference to Mr. Justice Scott Baker is at 19. I don't intend to go there. But what you see at the end of 15 is the court is unpersuaded as to the objections made by the claimants as to the adequacy of an alternative remedy. But what you will see in the last sentence is that in any event, they certainly could have been the subject of mediation, for example. Do you see that?
So which paragraph?
This is just at the top of 806, at the end of paragraph 15. And then finally, and this is really the key passage which is cited in the textbooks, it's paragraphs 25 through to 27. And again, if I could just ask you to read that. And you see the spirit of, I mean, unsurprisingly, given it's Lord Wolfe, you see the spirit of this decision essentially replicated in the pre-action protocol itself. In particular, paragraphs 9 of that protocol.
Have we got that in the bundle?
It's not in the bundle, but it's just a short point.
We've got the white book.
We've got the white book, yes, it's just page 2608
Volume.
of volume 1.
Thank you.
And it's really just paragraph 9 I just invite you to read.
That pulls in both directions, of course, isn't it?
It does indeed.
You should explore ADR, but don't forget you've got to bring
So
JR promptly.
this is what we're dealing with in terms of judicial review. You've got essentially a discretionary. the exercise of the discretionary jurisdiction for a whole range of matters. It could be a matter of immigration, it could be a threat to life, it could be unlawful imprisonment, or it could be an accelerated payment notice. And the requirements, for example, of promptitude will vary enormously. So, for example, if it's a very important decision, the courts may not allow you to take your full 3 months, then issue on the last day, whereas in other matters where, for example, as here, it's just money, the urgency of needing to challenge a decision within time is going to be much less acute. But what you have essentially is a general regime which will apply for a variety of matters. And yes, of course, you're exhorted to use alternative remedies or alternative dispute resolution. You're very strongly encouraged to use the protocol. And yes, you're right, my lord, that doesn't detract from the point that you still have to issue in time. But what the courts expect or are entitled to expect, particularly those who, such as here, are fully represented, is that the parties have to, or particularly the claimant, has to exercise judgment as to when is the appropriate time. Now, ultimately, if the claimant wins the case, they win. But there will be consequences, and the protocol makes it very clear, there will be consequences in terms of costs if you don't act appropriately. And obviously, what constitutes acting appropriately will vary enormously from case to case.
What paragraph 9 appears to contemplate is that time limits have to be complied with, so that if it's appropriate to issue a claim to ensure compliance, you do so, but then you agree to a stay. In one sense, isn't that what Mrs. Archer did? She said, I've got to issue my claim, but I'm prepared to consent to a stay.
Well, that is obviously one route open to you, but you may well be in difficulty if you haven't engaged either in a statutory mechanism such as 222 or the pre-action protocol. There was a complete failure, to be frank, in this case. And then you try and seek to recover what on any view were quite sizable amounts of costs in relation to that process. Just in relation to one point which my Lord raised this morning in terms of just asking the revenue for some further time, this was something which, it's not in our skeleton before you now, but it was pointed out in the skeleton before Mr. Justice Green. If you just take that up at tab 13 of the core bundle. Apologize, I've got a wrong reference there. Yeah, no, tab 13. And then if one goes to page 121 of the bundle, paragraph 41 of the skeleton, this is just after the revenue had drawn the decision of Mr. Justice Darwin for Kane to the court's attention. What you see then follows at 41. In this case, HMRC submit that insofar as there were any doubt on the part of Mrs. Archer, the proper course would have been to write to HMRC and invite them to confirm that no point would be taken on delay. And indeed, that was a point raised by Mr. Justice Collins. You can see from the footnote, it's not in the authorities bundle here, but footnote 3 is the International Masters Publishers decision, which after all was a JL decision against the revenue. So,
yeah,
way
because as my Lord said a few moments ago,
yeah.
Paragraph 9 of the pre-action protocol, in a sense, where it says, well, it doesn't actually, it doesn't actually alleviate needs to issue the claim form in time. And of course, the problem is that 54.6 requires the claim form to include, as it were, the kitchen sink. So everything you're going to rely upon, your statement, any evidence, your statement of grounds, any documents you're going to rely upon have to be served with the claim form. But your point, I think, is that it would have been open to Mrs. Archer to effectively invite the revenue not to take a point on time, and to the extent necessary, apply to the court for an order sanctioning that approach.
Indeed, but it's worse than that for Mrs. Archer, because let us not forget here that in relation to Mrs. Archer, everything had come to an end before the three-month time limit had actually expired in this case. She got her APN on the 4th of November. The revenue withdrawn before Christmas. The whole thing was over. To get round that, I would say, quite serious difficulty, we are then faced with the argument that somehow her claim had to be co-joined with her husband's. But leaving that point aside, even if one were nervous about the 3-month deadline, there was no attempt either to engage the protocol or Section 222, and then perhaps wait and see what happens as the 3-month deadline approaches. There was none of that here. It was an entirely premature application, we would say. And it gave the revenue no chance at all to engage with any of the arguments before potentially facing the size of the cost bill which was ultimately prepared.
The argument on paragraph 41 and Mr. Justice Collins in the case cited is really that it doesn't deal with a case where the deadline is approaching come what may. It's a way of avoiding the deadline ever arising, because you agree in advance that advance of the issue of proceedings that points won't be taken on time, so the deadline goes off into the future to allow the window for the ADR or the.
Indeed, my lord.
In light of which, as I said, as I put to Mr. McDonald first thing, no court would say, well, you're out of time. And if there was a concern about that, the short answer is you go to court to get the court to approve the stay.
Indeed, my lord, and all the more so in a pure money case, as it were.
Yeah.
And of course, there was no engagement along that line at all. There was no engagement, despite the wealth of advice and representation Mrs. Archer was receiving and being charged for. There was no engagement with even the pre-action protocol, which, after all, is written in language for a layman to understand, so that they can engage. And there has really been no adequate explanation at all as to why that wasn't engaged with. Still less the bizarre behaviour where proceedings are issued and only belatedly Section 222 representations are then subsequently made, as they were on the 17th of December. I mean, respectfully, this is a textbook example of how not to launch JR proceedings if one is hoping to recover costs in the event of a win. Of course, if matters had gone on to full hearing and it had been contested all the way, that might be something else. But you always run the risk that if there is an early withdrawal and you've completely aggressively overcooked the way you've approached the case.
Well, that's the point, isn't it? Because the costs that are sought to be recovered are the costs of issuing and serving all the documentation that I referred to.
Indeed.
So I suppose you would say, really, matters are put entirely the wrong way around when the Section 222 representations, when they were made, simply were one paragraph reproducing everything in the JR claim form, was, in a sense, makes your point that all the expenditure of the JR full-blown claim had already been incurred, whereas it could all have been avoided with perhaps a well-directed letter or two following the PAT procedure.
Indeed, madam. What we will see is really the bull point of what Mrs. Archer's case was, particularly Condition B, could have been made on a single side of A4.
Yes.
And
are you going to take us to the question whether this was in truth a joint claim or had to be a joint claim for JR? Or
well,
so that's one of the points made against
I will be addressing you on that. We would say not. That ultimately all of the points are severable as between the two claims, and in any event, if there were a concern about that notwithstanding, the issue has obviously arisen because Mr. Archer received his APN at an earlier stage than Mrs. Archer.
Yeah.
That's just a matter of fact. But if there were a concern for coherency with having both claimants heard together, as it were, that doesn't necessarily require the claim form to be issued on a joint basis. You could have a joinder later on. Particularly if you think, as Mrs. Archer clearly did think, she had a big knockout point. which would have taken her out of the running at an earlier stage. You can see that very clearly from the way the statement of grounds were actually prepared, and I'm proposing to take you to that in due course. But before I do, I'd like to, if I may, just take you to both the preliminary notice letter and the APN, just to make a couple of points. So, if we take up essentially the preliminary letter, which is behind tab 1 in the supplementary file. You see there at page 3 the letter, and then if you just look at under what happens next, you can see once you receive the notice, you'll be legally required to pay the amount shown in it within 90 days of the date that you receive it. That day may change if you make representations objecting. And then if we come on to the APN itself, so that's 4th of November, that's behind tab 3, starting on page, the covering letter's on page 13, the notice is on page 15. But if one turns over to page 16, again, it's part and parcel of this notice that your right to make a representation is drawn to your attention, and the effect of that is drawn to your attention. And then ultimately what we see, you've already been taken to the representations letter, which is just for your notes behind tab 6, that's the 17th of December. But what I'd like to do, because that obviously enclosed the statement of grounds, what I'd like to do is just take up the core bundle and look at what those grounds say, because I think this is relevant to some of the exchanges which were with my learned friend earlier this morning. So the judicial review claim form is behind tab 18, page 141. See, it's issued on the 28th of November, so less than a month after the receipt of the APN in Mrs. Archer's case. You then have a statement of facts and a statement of grounds. And what I'd like to do is just go to the grounds, and in particular, using the bundle reference, page 174.
As in
the
bottom,
lowest of the
bottom number,
the largest number, as it were, indeed. So you should have 3.9 and 4 at the bottom of the page. So 3.9, you see the complaint where it said that HMRC can't issue APNs to 2 different taxpayers in the alternative, but of course the Revenue's formal case was that they weren't in the alternative. And then at 4, it is apparent in this case HMRC are seeking to exercise the power to issue APNs in 2 cases where there is a genuine dispute, because again part of the taxpayer's case was that if there's a genuine dispute as opposed to a non-genuine one, and that prevents the issue of an APN. But it's over the page at 5.1, and if I could just invite you to read that. And that is because that line of reasoning does not apply to Mr. Archer. That's only for Mrs. Archer. It's only advanced in relation to Mrs. Archer. And that is what I've termed Mrs. Archer's bull point, i.e. I'm just not within the intendment of the legislation because I, for example, don't fall within condition B.
Well, that's the point, isn't it?
Indeed.
I mean, that is just saying you can't satisfy condition B in relation to me.
Indeed. And as cheap forensic point, but it's a point here made in this case that was made very shortly.
Yeah.
And was fully within, on any view, fully within the scope of the 222 representations mechanism. So, just having a quick survey of the facts, Revenue say that it's both the failure to engage with Section 222 and the failure to use the pre-action protocol, which was serious. My learned friend sought to cast equal blame in relation to the pre-action protocol on the basis that they never had a response to their pre-action protocol letter, which was, after all, issued on the same day as the same date the claim form was issued on. But of course, that was on the 28th of November. The Revenue had already withdrawn the APN by I think they'd indicated that on the 22nd of December. So it would have been an entirely pointless activity to then engage within the pre-action protocol in relation to Mrs. Archer, because the whole point was moot.
Well, I suppose to call it a pre-action protocol letter at all, if it comes on the same day as judicial proceedings, is really a contradiction in terms.
Well, it's a contradiction in terms, and also it is simply, if it was paying lip service at all to it, my lord, it wasn't really what one would normally expect to see when one has a pre-action protocol letter. The reason being, because all the pleadings were already drafted, so there was no point sketching out a case in less detail when you'd already gone to the great cost and expense. And bear in mind, they'd also done the witness statements at this point as well, of drafting out your case in full, without even seeing whether the Revenue were going to agree with that point, which I've taken you to at paragraph 5.1 of the grounds. So that is unfortunately the situation Mrs. Archer has found herself in. Leaving aside, we would say that this point is so obvious that we wouldn't even need to rely on the Section 222 mechanism to advise a court to make no order to cost, but in actual fact, we do have that, and as my Lord Henderson commented on, it's pretty, and as Mr. Justice Green found, it's very clear that Parliament intends you to use that mechanism.
And the truth it wasn't really a pre-action protocol letter at all.
No.
It was actually a letter effectively not quite formally serving the pleadings, but basically saying, here are our pleadings, we're right and you're wrong, give in, which is different from employing the pre-action protocol.
Indeed, my Lord. So, if I may, I'd like to, hopefully I can finish Burkitt before lunch, but if not, I hope to be pretty much done before the short adjournment, if that would suit. So if we can just turn up Authorities Bundle 1, tab 11. So Burkitt was a case where, as a matter of planning, there had been two distinct stages. There had been a resolution by the council to grant planning permission, and there had been the actual grant of planning permission itself. And what the claimant had done in this case was to await the grant of planning permission itself. The council then took a timing point, saying you're out of time, and the stage where this decision is engaging with this is that the Court of Appeal had agreed that the claim was brought too late. And you'll see that a large part of this, a couple of paragraphs of Lord Staines's judgment are set out in our skeleton. But where I'd like to start is paragraph 38 of the judgment. That's page 109 of the report. And if I can just invite you to read paragraphs as we go along, and paragraph 38 would be one I'd invite you to read now.
All right.
comment on at the moment here is what ultimately we will see with Lord Staines is that I'm obviously putting words in my own friend's mouth, but he is trying to present to you a binary choice as to it has to be this decision or that decision. It can't be both. And what we'll see from what Lord Staines says is, well, actually, you can, if you wish to, you could have brought a decision against the resolution, which after all might not come into fruition to a full grant of planning permission because other things could have come in the way. But what you will see is him going on to explain, for reasons such as last resort and all of that, that is no good reason to shut a claimant out if they decide to wait for the actual final decision as well. So again, if we could go on to paragraph 42, and again, if I can invite you to read that. So again, Lord Staines is very much rejecting that binary choice, which is presented. You're invited to adopt in relation to APNs and determinations of Section 222 representation. And again, the key point then follows at 43 that essentially you're inviting people to potentially completely waste their money, go to all the time and costs of initiating judicial review proceedings, if the actual decision under challenge is going to be academic, because, for example, in Burkitt's, the planning permission might not come to fruition, and in relation to ABNs, because the revenue might agree that actually they're going to withdraw.
Yes, I mean, what Lord Staines got in mind there are genuinely preliminary decisions which don't have legal effect until confirmed. It's not a precise analogy with APMs because they do have legal effect as soon as they are given.
Well, I'll be addressing my learned friend's Section 55(8)(c) points after the short adjournment.
Yeah.
But for the very large degree, I don't believe, well, certainly my own experience, I've never seen such a situation before. The reality of the situation with an APN, as Mr. Justice Green found, was that when you do make representations, the APN essentially goes into stasis. Because
But the APN itself says as much on the last page. It says that if you do make representations, then the time for payment is postponed until later of, and it's the second one, which is our consideration of your representations and determination of them.
And that's not in dispute in relation to the facts of this case, because you have two types of APNs. You have an APN issued during the course of an inquiry, that's this case, and then you have an APN issued during the course of an appeal. During an inquiry, an APN can never be enforced if there's a representation being made. And so on the facts of this case, it didn't really have any effect at all. It was in stasis, as Mr. Justice Green said. In relation to an appeal, there are, as I understand what my learned friend has said, two possibilities. If you've already got postponement, then the issue of an APN takes effect only after the representations mechanism has been exhausted. That's clear from 8D of Section 55. I think the point my learned friend is raising is, if in the short period of time between, when you appeal, say, a closure notice or a discovery assessment, in the same breath you normally ask for postponement. And you have to do that because otherwise the assessment is payable within 30 days. And so I understand the point my learned friend is making. In that particular, I would say potentially narrow circumstance, the APN does take an immediate effect because it prevents you from even applying for postponement at that stage. I think that's the point he's making, and I'll engage with that after lunch. But that is not this case.
Even more generally than that, the APN does take immediate effect. In order to...
Attention please. Attention please.
What we'll do is we'll write...
This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business. Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.